Hello, my beautiful friends. What an amazing day it is today, and welcome back. I hope your weekend was outstanding and amazing, and you're tackling the week bursting with energy, accomplishing all the things you set your mind to. We're working on that today. And we're excited that you're here and with us. We've got a bunch of news to attend to today. Two major stories I want to zoom in on. The first, of course, as you saw in the title of the show today, Trump going to the Supreme Court again. So we're going to spend some time on this one. It is a 34-pager. It's an application to stay a lower level injunction. Of course, this one is coming out of California, Northern District of California. And we'll see what they're asking for. This case involves the probationary firings. Of course, this is the AFL-CIO, a giant nationwide union representing a bunch of bureaucrats with as much respect as due. And they want their jobs back. So since they're such amazing civil servants who love America so much, they decided to sue America to force them back into their positions. And now the lower level judge issued a nationwide injunction. Trump's taken it up to SCOTUS. Says, hello, John Roberts, Amy Coney Barrett. Are you there? Hello. These are going to keep coming. You can stop these if you'd like. We just need a little action from you. But it's going to require you to step up and do something. So we'll go through that. We've got updates on who this judge is. And what's interesting is this was brought to my attention courtesy of Chad Mizell. Chad Mizell is someone who's been doing a lot of these filings, and you can follow him, of course, over on X at the top of our timeline. So check him out. He's interfacing with the public, which is great. So go check that out. Chad Mizell. He is the one who submitted this, or was a part of the submission of this. And so we'll get into it. We're knocking at the door of the Supreme Court. We love when that happens. We got more reaction. Trump had a hearing, a cabinet meeting today. Some press was allowed to come in there and hear from some cabinet members. Pam Bondi, you can see, to the president's left, and she had a short statement here for us on what is coming next. So these probationary individuals might be coming back, might be going, but regardless, we're looking into corruption. Whatever DOJ uncovers, and if there is fraud, Pam Bondi is going to prosecute somebody for it. Maybe. We'll see. So that is still yet to be seen. So we'll hear from her. We'll hear from Scott Bessent and more, all in that first segment. SCOTUS bound. Then we're turning our attention to this Boseberg saga. So, of course, we know Judge Boseberg out of the District of Columbia, another big one. He dropped a memo. He ordered a hearing over the weekend, made everybody come in on Saturday, then issued a memo saying that Trump is a bad person and the Venezuelans should come back, even though they are terrorists and more. And so we'll read through briefly his memo, because what's happening here is this is also up on appeal. So today there were several things happening. That memo came down, but Trump was also arguing on appeal. This was the case, of course, same case you can see here, JGG versus Trump. And this was in the Circuit Court of Appeals for the DC Circuit. So the next level court up above Boseberg. It has three judges that were hearing the case today: Walker, Childs, and Henderson, according to the court. Oh, no, it's not Childs. It's Millett. My apologies. I'll look up Millett. But it's Millett who is there, and we'll see what we got from her. So we'll see what was happening there today at the hearing in the District of Columbia Court of Appeals. And then we got some reaction. We'll see what Roger Parloff said about it, what Margot Cleveland said about it. They were both listening in today. And we'll listen to a bit of this ourselves. All right, I've got this queued up right to the juicy bit where they get asked whether or not these deportees are being treated worse than Nazis. Yep. We treated the Nazis better than we treated the terrorists. All right, so we'll listen to that. It's totally ridiculous. We'll come back to that, and then you'll want to throw a chair through the window thinking, these are our judges? Yeah, it's real. So we'll go through that. Then we'll come back. We'll see what else Jim Jordan has to say about it, because apparently they're hauling Boseberg into the Judiciary Committee, and we're looking forward to that one, right? That's another thing that we could always do. Just haul these judges in and have the judges just come in there and say whatever they say. I speak through my filings in the court of law, whatever. You know how it is. Then we'll hear from Tom Homan and once again from Pam Bondi, commenting specifically on Judge Boseberg and what else is coming up. So as you can see, we got some good stuff to attend to. We're glad that you're here and with us. I hope your week is off to just an absolutely outstanding and an amazing start. And of course, before we get into any of the heavy lifting today, you know what we got to talk about? Getting healthified and leanified, because we've heard of this concept of yo-yo dieting, right? You've heard this. You lose weight, you gain it back, you lose some more, you gain it back again, like a yo-yo. And it's not good. In fact, it's actually not good for your health. It's dangerous, they say. Studies show it can increase your risk of heart attack, stroke, type 2 diabetes, and either cause other health problems. And so we want to break free of this yo-yo diet pattern. That's one of the main reasons doctors created lean. Now, this is a supplement, not an injection. You don't need a prescription for it. The science behind lean is also impressive. Its studied natural ingredients target weight loss in 3 powerful ways. Does some amazing things. 1, helps maintain blood sugar, helps control appetite and those cravings, and it helps burn fat by converting that fat into energy. And so if you're tired of losing weight, gaining it back, doing the yo-yo thing, if you want to lose meaningful weight at a healthy pace, get some lean. It was created for you. And so we can get you started today, 20% off when you enter code Robert20 at takelean.com. Link down in the description, QR code up on your screen right there, code Robert20 at takelean.com. Check it out and get healthified and leanified. And we appreciate you supporting Lean, takelean.com, Robert20 at checkout. Thanks for supporting the sponsors of today's show. All right, now, without any further ado, let's get into the business on the day. Here we are. Trump back at the Supreme Court. He's trying to make sure that his executive orders carry weight, since he's the president and all. But what has happened here is lower court judges, in particular this judge called Judge William Alsup, who is out of the Northern District of California up there in San Francisco. He was appointed by Bill Clinton, as you can see here, and he's hearing a case currently about probationary employees who were fired by President Trump. And of course, Trump came in, Doge came in, made a bunch of quick changes. One of the easy changes is just to get rid of the probationary employees. Just say, you're on probation. You just got here. What do you think? You're entitled to tenure? You got here 5 minutes ago. You're gone. We don't need you. Thanks. That's the whole point of being on probation. So they fired these people. And then, of course, the so-called civil servants who have been dedicating their livelihood and all of their generosity to the American spirit, whatever. They're employees who took jobs at the federal government who were like, well, we get how many days of vacation? How many days? Well, I don't know, it's not as much as I was expecting. You get a lot. All right, just take it. So they then are so heroic and such good people, they decided to form together, create unions. And then those unions, in addition to getting all of those government benefits, they also decided to sue. That's how much they love their country. So they did. They sued. And this judge, who also loves the unions and hates Trump, apparently, was someone who then turned around and granted the injunction and said, Trump, no, you got to hire these people back. Bring them all back. They're amazing civil servants, So now Trump is appealing this to the Supreme Court, asking them for a stay, right? The judge forced him to hire them back, issued an injunction, an order saying, bring them back. Trump is saying, can we please stop this now for the love of, what are you doing, judges? Amy Coney Barrett, John Roberts, wake up. You can put a stop to this. So this is knocking on the door of the Supreme Court. We know who's involved. They're suing everybody. It's all these heroic entities like the AFL-CIO and all of these people here. Oh, the Coalition to Protect America's National Parks is here. Great. And Climate Resilient Communities. Oh, that's good. And the state of Washington and the United Nurses Association of California. Oh, wow. They're all here. What a bunch of heroes just fighting the dictatorship in America. So here's what we have going to the Supreme Court. They say, listen, all right, unite. This garbage has been going on for a long time. My words. Then they start. They say, pursuant to the rules of this court and the All Writs Act, we are now, Trump, filing this application to stay the preliminary injunction that was issued by Judge Alsup in California. Now, this is pending in appeals in the Ninth Circuit and elsewhere. It's working its way up. But we are at your door. And if they do affirm the injunction, then just turn this into a petition for a writ. Whatever you got to do, interpret this however you need to. If the Court of Appeals changes something, then it's a writ for a petition of certiorari, or if not, it's an application for a stay. So however it is, you interpret it. But here's the thing. Supreme Court, we got to do something. Here's why. The district judge in this case, Bill Clinton's Judge Alsup from San Francisco, in this case spontaneously issued a preliminary injunction ordering a half dozen departments and agencies to immediately offer reinstatement to over 16,000 probationary employees. Who had been lawfully terminated. 16,000 people fired. They take their boxes. They get out. And like, Trump's a dictator. I can't believe this. And they take their boxes. They come on back. So they were playing solitaire at home for a couple of weeks. Now they're going to go play solitaire in these buildings again. So the district court did so in a suit filed not by the employees themselves. Okay, these aren't people who got fired. These are the unions. And what are the unions mad about? Well, they represent the federal employees and they take a skim off the top of it. They take a portion of their paychecks, right, like taxation, right into their accounts. So they're losing money when these people are gone. They're losing all of that money. Those are their claims, not mine. Those are what they're writing in there. We're losing hundreds of thousands and millions of dollars. But anyways, they turned into these groups, right? And by the way, the employees themselves, if they sued by themselves, those claims are channeled through administrative procedures. They can't sue themselves. There's a bunch of other jurisdictions that are set up for their complaints. So they have to bundle them up into these little groups, and then the groups sue and they say, we're being injured. And then Judge Alsup from San Francisco comes out and grants them relief. It's by a group of nonprofits who claim that these layoffs could contribute to downstream harms if the government doesn't provide its nip for them to teat off of. You get it. Now, and the court issued this sweeping relief on the theory that the agency decision makers wrongly believed that the OPM had directed the terminations, even though the OPM clarified in response to the court, and even though that the 6 enjoined agencies subsequently chose to stand by the terminations. They're like, well, you didn't have the right authority, and we've gone through this many times here. They have the right authority. They just have to draw the chain. Like, judge, just follow the bouncing ball. And you can see it goes back to President Trump. And the good news is he's the president. So now you know. Now, the court's preliminary injunction thus let third parties, like these unions, hijack the employment relationship between the federal government and its workforce. And like many other recent orders, Supreme Court, the court's extraordinary reinstatement order, shoving 16,000 people back into the executive branch, violates the separation of powers. The courts can't shove them back in, arrogating to a single district court the entire executive branch's powers of personnel management on the flimsiest of grounds and the hastiest of timelines. That is no way to run a government, Judge Roberts. This court should stop the ongoing assault on the constitutional structure before further damage is wrought. Now, throughout February 2025, Supreme Court, Trump's DOJ says, as part of the administration's efforts to streamline the federal workforce and to address the unsustainable federal expansion, multiple agencies everywhere terminated thousands of employees in probationary status. That means those who have yet to establish their qualification for continued service. We don't know that we need you. You're on probation. And not like you got in trouble, right? Sometimes you get in trouble. You're like, whoa, we saw you stealing staplers last night. So don't do it again. You're on probation. Next time you're fired. Not that. It's just like, hey, we're trying you for 90 days. Want to make sure you can type an email up and remain in their 1 or 2 year trial periods. Now, some of those employees have since filed complaints with the Office of Special Counsel, like they're supposed to do. And one of the agencies pursued administrative relief through the Merit Systems Protection Board, right? There's a lot of federal employees, a lot less than there used to be, but there are still a lot. And so there's an entire system set up for this so that they don't sue in federal district court in Washington, D.C. and clog the systems with their complaints. I was wrongfully fired. Why? Because I had to do something sometime. Okay. But no employees are plaintiffs in this lawsuit. They're not even here. The respondents who claimed and made this lawsuit form the basis of this entire injunction are instead nonprofit organizations whose members use government services that have, at best, only distant connections to the terminated employees. But somehow they have parlayed those alleged harms as the late opening, here's one harm, of a national park's bathroom facility. Yeah, it's going to be delayed. Somebody's going to have to go in the woods in Yellowstone. So what that means is we have to hire 16,000 people back to reinfest the federal government. Just go outside, okay? You're in nature. Just enjoy it. National Parks bathroom facility. Or supposed dilatory FOIA responses, right? Oh, they're going to be too slow in FOIA. So what that means, the judge says, yeah, that's a big problem. Somebody might wet themselves standing in the trees, ordering 6 federal agencies to immediately reinstate to full duty status more than 16,000 terminated probationary employees. Gosh. So that injunction is especially remarkable, saying you have to take these people back, given that the respondents, the unions, did not even move for it. They didn't even ask for that. The court issued an oral preliminary injunction from the bench at the end of the evidentiary hearing, right? And unfortunately, these judges don't live stream these hearings. They'll live stream the Court of Appeals hearings, but they won't let us into their courtrooms when they're doing this type of garbage under the dark of night in the gutter. Later followed by a written opinion. Now, the district court order thus expanded relief far beyond the initial TRO, which had simply required the OPM to update its guidance to make it clear it does not have the authority to direct personnel actions at different agencies, right? So this judge is just like spring-loaded. This is happening all over the place. This is why these judges are installed, and that's why these lawsuits are filed in these jurisdictions. It's forum shopping to pick the best judges, and the judges are just looking for a reason. They're like, Your Honor, can you just adjust this language here, just make sure they don't? No, we're going to do more than that. 16,000 people get their jobs back. Like, what? We don't even have that many people in our unions. There you go. They're all back. Enjoy. The grift is on. So the notion that immediate reinstatement of thousands, Trump writes this to the Supreme Court, thousands of probationary employees, thinking that that is the way to improve customer service at the national park bathroom, also underscores the fatal flaws with their theory of Article 3 standing. To call their theory of standing attenuated is charitable. They speculate that the OPM's original guidance, not the agency's own assessments of whether these probationary employees are necessary, prompted agencies to terminate the probationary employees, thereby hampering specific services like bathroom access and FOIA responsiveness. That would have been unaffected without the terminations. So they wanted make some minor changes originally, and the judge went hog wild. Now, and those inferences cannot establish Article 3 standing, nor can respondents link their theory of illegality, saying that the OPM, the Office of Personnel Management, lack the authority to direct these terminations to the injuries they assert. If organizations could establish Article 3 standing just by positing that fewer government employees will translate to less optimal government services for their members, then anyone anywhere with contact with the federal government could second guess any agency's personnel decisions down to which federal employees work which hours. You can't fire anybody, like ever, because that person does something and you need them to do the thing. I mean, otherwise you got to replace them with kind of like 2 people, because that person was already trained and that you're going to need 2 people to do their work until one person gets trained up. It's just like, what? You have to maintain every single service. Therefore, nothing can change, which is what the judge has basically ensconced in his order. So declaring open season on challenges to federal government management is especially unsound, writes Trump, because Congress has created an entirely different framework for resolving legal challenges for fired employees. Now, as this court held, the Supreme Court, you guys, when employees challenge terminations when they proceed, if at all, they go under the Civil Service Reform Act of 1978. Congress created that. That allows strangers to the federal government employee relationship to head straight to district court. Allowing strangers to the federal employment relationship, in this case, the unions, right? The unions are not in any contractual or employment relationship with the government. The employees are. The unions are just claiming harm because they're not getting money, but the harm is kind of not to them, it's to their members. Because certain people will be fired, their members will get less potty time when they're hiking around in the forest. That's the harm to them. And they're going to be harmed too, so that's why they have standing. What? They're not even a part of any contract, any relationship at all. So what they can then do is just go straight to district court. Like, district court is reserved for important stuff, not whiny unions or federal employees. So this court should not allow a single district court to erase Congress's handiwork. They created an entirely different process for this. Now they seize control over reviewing federal personnel decisions. Much less to do so by vastly exceeding the limits on their authority and ordering reinstatements en masse. 16,000 people coming back. Now this court, the Supreme Court, you guys just sort of remember this court has recognized that the judicially compelled reinstatement of even a single government employee represents a substantial intrusion into the executive. Even one, This court has required a heightened showing before permitting that remedy, so as to preserve the executive's traditional, quote, latitude in the dispatch of its own internal affairs. It would be like Trump going in and saying, Judge, you have to change your law clerks out. I don't want to enforce the law as to them anymore, so they're all going out, and I'm in control of the court's entire staff. Bring them back. Judge fires a clerk. Nope, you're gone. Nope, bring them back. Nope, I'm not paying for this new one. I'm not going to enforce the building key card or something. We're not going to hire security. Bring them back. It's ridiculous. This is the executive branch. Trump fired them. If they got wrongfully fired, they can make back damage claims for back pay and whatever. But this forcing them back in is putting people who should not be there, according to Trump. Maybe there's good people in there. I don't know. Doesn't want him in there, whatever the reason. And that's his executive branch. So they say, get out of our affairs. Now, moreover, no statute, certainly not the Administrative Procedure Act, which is what they're suing under, that forms the basis of this lawsuit, authorizes the use of reinstatement to redress downstream harm because there's no porta potties out there for Elizabeth Warren, who's out there building teepees, to the potential beneficiaries of the services generated by a particular employer-employee relationship. They're not even a part of this, these unions. Nor have the respondents come close to making a heightened showing that mass reinstatement of 16,000 probationary employees is even necessary, especially after the government had already remedied the supposed legal mistake by making it clear that OPM cannot and is not seeking to direct the terminations to other federal agencies, right? So OPM is not, for example, bypassing the Treasury and firing people. They just manage things and they consult and they say, hey, Treasury, here's what we found. Treasury says, oh, great, thanks, OPM. We're going to take care of this. Thank you for the notice. Then they fire everybody. That's the chain of command. There is authority to do it. So Judge Alsup out of San Francisco, the district court's extraordinarily overbroad remedy is now inflicting ongoing irreparable harm to the executive branch and us that warrants the Supreme Court's urgent intervention. John Roberts and Amy Coney Barrett, every day that the government remains subject to the injunction by this judge and many others inflicts intolerable harm on the functioning of the executive branch. Judge Alsup of California has compelled the government, Trump, to embark on the massive administrative undertaking of reinstating and onboarding to full duty status thousands of terminated employees in the span of a few days. Now, exacerbating the burden, the district court Judge Alsup has insisted that employees must be returned to full duty status and staffed so as to restore the services that the respondents seek to use, because Pocahontas has been out there holding it for months. And the government is required to reinstate employees to active duty status and provide them with assignments, all subject to the ongoing supervision of the district court. Put them back in the CRM, make sure they get their tasks checked back on, make sure they go to the meetings, invite them to the next Zoom meeting, get them their donuts again. Don't give them oatmeal. The injunction appears from this judge to prevent the agencies. So the judge is in charge. Like the judges, are their key cards working? Yes, Your Honor, they are. Okay, good. Do they have their favorite sodas there? Yeah, all right. Good. Is it the sugar-free kind? They hate that. All right, yeah. No, we got the sugar, extra sugar, whatever. They love it. All right, good. All right. Court's adjourned. The injunction appears to prevent the agencies from terminating the employees based on their own independent judgment or even newly arising grounds, saying, okay, let's say Trump doesn't fire them on his new decision, a new executive order or memo that goes out. What if somebody just says, that dude literally stole the printer? He's like walking out with the printer. Can we fire them? No. You have to get clarification or permission from the court. Judge, he's stealing the entire computer server. Can we please do something about it? Well, let me see. Do you have any photos? Please text me. The ensuing financial costs and logistical burdens of ongoing compliance efforts of doing this, hiring, firing, and then rehiring is immense. And so given those profound harms made particularly intolerable by Judge Alsup's injunction and its sheer scale, 16,000 people, like that's ridiculous. The government sought an administrative stay and requested a decision by the Court of Appeals by last week, Friday. Now, the Court of Appeals denied an administrative stay over the partial dissent of another judge there. And as this application is being filed on Monday, today, the date of this recording, the Court of Appeals has yet to rule. So every day that the injunction remains in effect is a day that 6 executive agencies are effectively under the district court judge's receivership, right? The judge is in control of them, necessitating immediate relief from the Supreme Court of the United States. This judge is in control. 6 agencies, can't fire anybody, can't make any changes. Somebody could be walking out and stealing your lunch, and you just have to keep him. Sorry, he likes to steal lunches. That's federal government now. So Trump's DOJ writes to the Supreme Court, this preliminary injunction also contributes to an untenable trend. In the 2 months since Inauguration Day of President Trump, district courts have issued, Supreme Court, more than 40 injunctions or TROs against the executive branch, which are essentially the same thing in the method that they're being used. Saying, whereas district courts issued 14 universal injunctions against the federal government through the first 3 years of President Biden's terms, 14 for Joe in the first 3 years, they issued 15 universal injunctions in February alone against Trump. And there, of course, their reaction is always, well, Trump is a dictator and Trump is taking over America. And so we have to do this. Yeah. Remember when the Supreme Court literally told Joe Biden, you can't do the student loan thing, and then he went around them and did it anyways? Where were the injunctions to stop the federal government from mandating you do something with your body or else you lose your job somewhere? A lot of people sued over that. Federal government, I don't know, put it in or you're fired. Didn't care at all. How about an injunction to force Joe Biden to, secure the border rather than importing millions of people in over his term? Never happened. They just let it go because they're all favorable judges. Now, what has happened now is they've gone just nuts, right? They've lost the control of Congress, control of the executive branch. They had no idea that this was going to happen to them. They thought they were going to prosecute Trump. They thought he was done. All right, just to be clear. In hindsight, it's like, okay, we realize that they overplayed their hand in hindsight and the American people caught it, but that wasn't even the end game, right? It wasn't just political. They wanted him in jail and they wanted him off the ballot. The Supreme Court had to come out and clarify that. So now that all that has come to a head, they've got just the courts and they've got these hack judges who are pretending to be impartial and fair and neutral, issuing injunctions hand over fist. So they say, look, Supreme Court, this situation is unsustainable. Emboldened by the lack of prompt appellate review, which is by design to just drag this crap out, which every day, right, justice delayed is justice denied. Every single day that Trump doesn't have his way is a day that they've stolen from the American people. All right, they're going to whine about January 6th for years. That was 4 hours of delay on a rigged election. This is months and hopefully not years, but days certainly of stolen governance that is being stolen from us. It is unsustainable. And John Roberts and Amy Coney Barrett can come out and do something about it. The other 3 conservative judges want something done. District courts have now issued dozens of orders without sufficient regard for their limits of their own jurisdiction or to defects in the plaintiff's representation about the law or the underlying facts, that many of them are suing in the wrong jurisdiction, should be suing elsewhere in the Court of Federal Claims. Those orders have sown chaos as the executive branch now scrambles to meet immediate compliance deadlines by sending huge sums of money out the door, reinstating thousands of lawfully terminated workers, undoing steps to restructure the executive branch agencies, and more. What they have done to interfere and insurrect the government is exponentially more harmful and insurrectionary than anything that happened on January 6th, which was a 4-hour protest, arguably a riot, if you don't consider the fact that there were police officers shooting people in the face with projectiles, instigating the whole thing with guys like Ray Epps, who were given virtual appearances, pleading to misdemeanors, being called heroes, instigating the initial breaches, and people being patted on the shoulder and waved into the building as instigators and more. So the list goes on, but this is a takeover of the executive branch. Now, of course, Trump is going to continue to motor forward, and a lot of this is just going to be on paper. And and Trump is going to do everything he can to comply for political purposes. But the people that are coming back into the executive branch are not going to be playing nice with these people that are being shoved back in. This is why this is horrible policy. Oh, so what are these 16,000 people going to do when they come back? What kind of projects are you going to put them on? They're all going to be excommunicado. So the lower courts should not be allowed to transform themselves into an all-purpose overseer of the executive branch, of hiring, firing, and more. Only this court, the Supreme Court of the United States, can end the interbranch power grab. And maybe they will. So Trump's statement continues, telling us, Supreme Court, look, the OPM assists the president, all right? We're going to get some background on this. Now, the OPM helps the president oversee the federal workforce. Congress has given us clear rules on this in U.S. Code. Aids the president. Federal law says the president may also provide for a period of probation for federal employees before an appointment becomes final, right? So the president has authority under U.S. Code. Congress empowered him to do that. Pursuant to the authority, OPM has issued rules that defines what the probationary term is. The Civil Service Reform Act also establishes rules. Federal employees on probationary period generally do not have a right to appeal. And it includes a bunch of other rules. So Trump came into office and knew about those rules. On January 20th, President Trump came in. He acted to optimize the size of the federal workforce and to limit hiring to mission-critical positions. Trump issued a memo instituting a hiring freeze and ordered other agencies to identify ways to reduce the size and the scope of the federal government. Now, the same day, OPM Acting Director Charles Ezell transmitted a memo saying, hey, this is guidance. Fire probationary people. Think about it. Should identify all employees, should promptly determine whether they should be retained, right? Go out, start looking for these folks. Then on February 12th, another email went out. Email instructed staff heads saying, use the attached template to separate from these people. And here's a tracker letting us know which ones you fired, which ones you kept. A little spreadsheet there in Excel or something. On February 14th, OPM sent an email. They explained, an appointment is not final until your probation is over, okay? So you're on notice. Then they again sent another email. They got a bunch of questions about it and more. So then on February 13th, federal agencies terminated numerous federal employees. Department of Veterans Affairs, for example, 1,000 afuera. Consistent with Trump's order. Department of Ag announced the same thing. DOD also said, we're reevaluating and more. Then on March 4th, OPM revised its guidance to say, look, OPM is not directing agencies to do this, okay? Ultimately, the agencies have the ultimate decision-making authority. So we're not in charge. You're the Secretary of Treasury. You run the Department of Veterans Affairs. You run the DOD. You make your decisions. So then, of course, for labor unions, yes, the amazing civil servant entities filed this action on February 19th. Then they added a bunch of other people. Main Street Alliance, small businesses, yeah. Coalition to Protect America's National Parks. You hate the national parks, Rob? Yeah, I hate him. A nonprofit organization for the National Park Service, Western Watersheds Projects, and of course, Vote Vets Action Fund. Yeah. They sued. They said that they acted in excess of their authority. They can't fire anybody. Who do they think they are? The president? On February 27th, the district court issued a TRO, Judge Alsup. In a written order the next day, the court determined that it likely lacks jurisdiction to hear this case because the claims at issue are more like FLRA and MSBP actions, is what the district court said. But the court took a different view as to the organizational respondents. Okay, so some of the people had said, well, you can't really sue because you are individuals, so go sue through these other entities, but the unions, you can still be a part of this case. Then the court said, I can hear this case because it's undermining your agency, and your agency can't appear before a labor board. So the district court also said that the organizational respondents have standing, right? The court found that the claims against the four claims against four of the agencies based on their assertions that members will suffer delays, right? So there it is. So they sued the agencies. They said the agencies will harm our people, and the court bought it. So then the court asked for a restraining order, ordered a restraining order, saying, yeah, there will be irreparable harm. You're going to lose your national parks. Diminish government services. It's going to create hardships caused by these firings. So then the order said that the memo and the emails were illegal and invalid, and it has to be stopped and rescinded. So then OPM promptly complied with that. Then they filed a second amended complaint, right? So these hack unions are like, we got one here. We got a fish on the line. We got one. Perfect. Amend it. This judge has already given us what we wanted. Now we're going to add in a bunch of other people. We're going to add several plaintiffs. We're going to name a bunch of other federal agencies, because if you add more federal agencies, then they also have to rescind the firing of the probationary employees, right? So bring them back, just expand the scope of it. So then on March 13th, the district court held an evidentiary hearing, at the conclusion of which they issued a preliminary injunction, even though they never even asked for that. They then ordered everybody, the Department of Veterans Affairs and everything else, to immediately, Treasury, Ag, Interior, and more, without waiting for a written order, immediately offer reinstatement to anyone who was fired on the 13th or 14th, 25. Cease any termination of probationary employees within 7 days. Get us a list of who was fired and why. The court stated it must extend relief to other agencies. And so no firing of everybody, of anybody. The district court then also issued a written injunction ruling the following day. It said, here's what I said yesterday in court. Incorporated its prior analysis about why these people can be here and more. Then on March 14th, the government sought a stay, right? We're getting closer to where we are now. On March 17th, Court of Appeals denied that. In the briefing, we are now here at the Supreme Court, fast forwarding to current date. So a lot of history. Here's their argument to the Supreme Court. They say, first of all, under the rules and the All Writs Act, this court may stay a preliminary injunction issued by a lower court, which is what we're talking about. Just that judge has shackled us from firing these people and ordered them back. So just get rid of that. Let us do our job. So to obtain that relief, Trump must show a likelihood of success on the merits, that he's going to have his case heard by the Supreme Court, because they haven't opened the door yet. He's just knocking there. And that there is going to be a likelihood of irreparable harm, right? If we have to hire 16,000 people back, that's going to cost us a lot of money and time and resources. And think about the national security implications of that. In close cases, this court will balance the equities, and all of this Supreme Court, all of it, supports a stay here. Stop what this judge has done. So they write, listen, Judge, we are going to win. Supreme Court, all 9 of you, we're going to win. Why? The respondents here, these unions, are nonprofit organizations who challenge the legality of various firing decisions. And they say that it's going to harm their union members' ability to access national park bathrooms to go potty and pee-pee and poo-poo and other federal facilities or benefits. The district court responded by issuing ALSUP. He's like, I hate it when I'm hiking. Maybe the judge has loose bowels or something. It's like, I hate that on the national parks. I love going out there, but I can't make it more than a quarter mile because I get this, where's all that? And so he's trying to figure it out. That's probably what's happening. Forcing the government to rehire and immediately reemploy 16,000 federal probationary employees so this judge can take a dump. The government is likely to succeed on the merits of its challenge to that extraordinary order. It is going to succeed because it's ridiculous. Gosh, just hold it. Go before you go hiking. It's not a big deal. All right, so they continue. Hey, Supreme Court, listen. Organizations whose members use government services, okay, well, we can't go potty in the forest anymore. That doesn't give them standing to challenge the terminations of government employees. The courts do not sit to adjudicate the public's views about how the government should run. It's not their job. They're the courts. How the government runs is left for the people to have a say in, which is why we elect presidents and representatives, but to redress legally cognizable injuries to specific protected interest judges. Writing to the Supreme Court, under Article 3 of the Constitution, federal courts do not exercise general legal oversight of the other two branches, right? That's not what they're there for. They're not like a hall monitor over the other branches. They're co-equal. They're not in charge with oversight. Instead, a plaintiff who's suing must establish an actual injury that the courts can recognize. This requires a bunch of other things, including an actual harm. And so to establish a harm, there must be an actual injury. In granting this, they relied on the end users of government services to establish standing. So that's you have to think about this from the Supreme Court's perspective. Like, okay, is this what the Supreme Court is going to say counts for standing? Anybody who isn't getting whatever they think they should be getting from the government, who can make a claim to some cut somewhere, can sue in federal court about that claim. You know what that's going to do to the courts? It's going to be ridiculous. You'll go to the MVD, you have to wait in line. Last time I was here, I only waited 10 minutes. Now I'm waiting 20 minutes. Were there cuts here? Yeah, unfortunately, we had to nope. Why'd you fire them? You should hire them back because there's legal precedent now that those judges have set because the end user is suffering something. I'm a part of a union. Those people were fired, and now now I can't go potty in the forest. So significantly, in entering relief against two of the enjoined agencies, saying you have to hire these people back, the court appeared to rely solely on the theory that the organizations themselves suffered an injury by having to divert organizational resources to counteract the agency actions. Wow, okay, so the unions now can't just sit there on autopilot and have their checks, their union members' checks just kind of grifted off, skim off the top, right? Siphon a portion of that, like withholding, essentially. Now those people are not going to get those checks for them to grift off of, and now they're going to be needing union services. So they're going to have to divert resource services from their mailbox money auto payment feature to actually doing something useful for their members. Like, oh, it's going to be expensive. We're going to have to do something here. So the standing theory is squarely foreclosed by the Supreme Court decision in another case, which said diverting resources is not standing for injuring in fact purposes. And the district court's remaining standing analysis is hardly better. Judge Alsup. The court determined that organizational respondents, the unions, may suffer indirect harms because the termination of probationary employees might cause delays in government services. Yeah. So your MVD problem is a legit claim, according to them. but the organizations offered only speculation that the terminations will impair or delay specific government services, right? Just speculating about what? Nothing's changed, right? Elon got rid of a bunch of people on X, and it's better than it's ever been, right? So we're saying you actually don't need all those people to do all these things. Now, one respondent, for instance, asserts that terminated employees at the Small Business Administration will make access to financial assistance slower and less reliable. So they're not going to get paid as quickly. And that's going to have ripple effects. And Yosemite National Park will also likely have to stop specific functions in closed park areas in Yosemite, man. Because I guess 16,000 people were going to be there making sure it was open. When there was a partial government shutdown, visitors trash scenic viewpoints. It's so amazing. They always close like the public facing stuff. You're like, no, you can't. They close up like Yellowstone. It's like a nature path. Like you just want to walk around outside. Like, no, it's closed because your government hates your guts. Okay, thanks. I guess we'll go somewhere else. The district court found Article 3 injury from the possibility that given, right, the judge is saying, well, it's true, I might have to go poop out there, says BLM may be unable to provide timely land health assessments and that Fish and Wildlife may be unable to meet deadlines in separate litigation. I know, it's horrible. So the organizations then identified only a handful of concrete examples and in delays in government services. They said that a bathroom facility in Joshua Tree National Park, which I think that's California, right? So the judge likes to go out there, remained closed well after its scheduled opening time. Wow. Supposed to open at 8, opened at 11:30. Wow. During one organizational member's visit, he's like, I went to go poop in the Joshua Tree and it was closed. And that the staff member at BLM identified staffing issues as the reason it was unable to respond to a FOIA request. Now, those allegations are a far cry from establishing that the terminations, the firings themselves, caused a particular reduction in those services. Might have just had a bad day, right? Somebody just might have not been able to come in that day to open up the shop, let alone that they would continue to do so going forward, or that the particular service respondents would resume to their liking if we brought these people back. Like, do you think that bathroom is suddenly going to be opened and nicely maintained since these 16,000 people came back? I don't know. Respondents claim the redressability are because the district court judge, Judge Alsip, said that each agency still had discretion to hire and fire. But in other words, even without the OPM, they could have fired these people independently, right? So they didn't need the memo. This is the same pattern we've seen here for a long time. The independent source theory that Trump, yes, issued a memo. There were new orders that went down, but they didn't need it to do any of those things. They could have fired these people anyways. And you know what's interesting about this is they know that at this point. So a lot of this feels to me like it's kind of red herring stuff. They're like, just issue a new order. For example, we've seen this, I think, most concretely with the executive orders about the law firms. So here's an observation. Trump issues an order against Paul Weiss. Executive order, law firm, big anti-Trump law firm, worked with Mark Pomerantz in the New York Judge Merchan prosecution. They do a deal, Paul Weiss and Trump. There's a second executive order that's issued before the deal, which is with Perkins Coie. Perkins Coie sues. Haven't done a deal with Trump yet. We're going to litigate that out, currently in Barrel's courtroom, and we've covered that case a lot here. Then Trump came out with the third executive order that we talked about over the weekend, which is also going after law firms, knowing that they're going to sue him again, right? But he's still making these changes. So part of me feels like, and I know many of these lawsuits are frustrating, but part of me feels like he is doing this by design. It's like the red herring, shiny object strategy. Issue a new order. All the resources are going to go into that order. Trump's going to bypass using that order because they've already identified the independent source to do this. And they're just going to go around them and flank them, use the independent source, cancel them anyways. And meanwhile, honestly, as frustrating as these are very expensive. There's a lot of litigation and a lot of expense and a lot of expenditure that's going into this from these lawyers all over the place. And the federal government basically has an endless, coffer of funds to constantly dip into. So it's almost like a shield, a red herring, so to speak. Could be one way to interpret a lot of this. In other words, knowing what's going to be coming next. They're using independent power to make what they want to happen. So, in other words, they say, at minimum, the handful of particularized allegations that they say that some of these have suffered cannot justify sweeping relief of putting 16,000 people back. Here's one example. The injunction has required the reinstatement of more than 1,000 seasonal employees at the Forest Service who were not in pay status. Like, we didn't even hire them. This was off season, but we had to bring them back anyways. That relief could not have redressed any certainty impending injury. And more fundamentally, ordering the reinstatement of 16,000 employees is an absurd way to remedy an injury from a delayed bathroom opening. Okay, one member really had to go. The park didn't open. And that's what his complaint is about. I had to go. It was closed because Trump fired someone. So bring back 16,000 people. Respondents have also failed to identify any case or historical practice for this. How can one court micromanage federal personnel policies? On their theory, any plaintiff purportedly aggrieved, here we go, by deficient government services might even seek to compel terminations of underperforming employees and then compel the government to hire better workers. Yeah, I like that. You go interface with somebody like, you're a moron. You're getting fired. I'm suing. This wasn't fast enough. I'm aggrieved. I like it. I'm aggrieved now. And you'll be hearing from my lawyers. Unless this happens quickly. You have everybody at the MVD. Might work. Hey, the kind of injury that they assert is plainly not one traditionally thought of to be capable of resolution through the court. So the district court's theory of standing is also untenable, Judge Alsup, because the central claim in this case is that OPM unlawfully directed other agencies to fire people, but they didn't. They already issued guidance. They said this specifically. We're not directing anybody to fire anyone anywhere. And so for that reason, there is no harm that they can directly connect to OPM in the firing of these probationary people. We're not even relying on the other powers. Deeming OPM guidance invalid doesn't restore the jobs because we had independent sources for getting rid of these people. And so now we also know that this court does not have the jurisdiction to even hear this case in the first place. Trump's DOJ writing to the Supreme Court, they say, Your Honors, the district court issued an injunction based on its determination that the dismissal of employees was unlawful because OPM was involved. But here's the problem. It lacked jurisdiction to assess the legality of Trump's executive order and his personnel decision. Basically, not even the order, the personnel decisions coming from the executive branch. Congress has already established an alternative mechanism when people who are fired have complaints. They go through the FSLMR statute, Federal Service Labor Management Relations statute. That scheme permits some, but not all challenges, with some challenges limited to certain types of employees. It channels those challenges to agencies and grants exclusive jurisdictions to the Federal Circuit over appeals from any final agency actions. Okay, so all this is saying, it gives us this nice scheme, this nice system for these claims to materialize in. Now, if end users of government services, okay, if you go to the Social Security Administration and you just waited too long or somebody screwed up your form or whatever, if that's all it took, if all of us could challenge the legality of personnel actions and obtain reinstatement of terminated employees without the constraints that apply to the aggrieved employees and to unions that represent them, that would turn upside down the entire structure of the law. By privileging end users of government services who are, at most, indirectly affected by a termination over the employees whom the legislative scheme seeks to protect. Okay, so in other words, we're now thinking about the end user, right? We're thinking about the person who is the recipient of the government services not about protecting the claims of the person who was fired, because it's now based on the services. Allowing separate litigation would seriously undermine why we created this entire scheme. Like, Congress built this for a reason, so that employees could go through it. So now we can just bypass that? The district court acknowledged Congress and their comprehensive system and says it also foreclosed claims by union respondents. The court took the view that the CSRA likely poses no obstacle to other lawsuits who are not entitled to administrative or judicial review. But that gets it backwards. The exclusion, writes Trump to the Supreme Court, the exclusion of end users of government services from the provisions establishing judicial review for personnel action prevents them from seeking review. Explaining the exclusion of plaintiffs like organizational respondents like the unions here reflects Congress's considered judgment about the limitations on who should be permitted to sue. In other words, Congress says we don't want the union suing over this stuff. They don't want them to have carte blanche to sue without using their system. Okay, it's for the people. It's not for the unions. So ordering the government to reinstate 16,000 people was unlawful. The government is also likely to prevail on this, Supreme Court, Roberts and Amy, because the court badly exceeded the scope of its equitable authority by ordering reinstatement on a mass scale for a perceived violation. Reinstatement is not an available remedy under the APA. They're suing under the Administrative Procedures Act, but it doesn't say under there that you can shove 16,000 people back. And even where reinstatement is a permissible remedy, this court has recognized that it requires an elevated showing, a showing that their threadbare theory of injury, because they don't have porta potties out there in Joshua Tree, is not enough. That sweeping remedy is all the more unwarranted because OPM has clarified its role. There is no legal harm or legal problem. And so the district court remedy, Judge Alsup, also exceeded the scope of his power. Bunch of case law there. This is now creating a new remedy. When Congress departs from its preferred mechanism, it tells us. But here the respondents, the unions, they're neither entitled to proceed under this or that. And neither the courts below nor the respondents have identified any statute that authorizes a court to reinstate public employees. Like, where is that in the law anywhere? So the district court lacked the power to do it. Now, even where Congress has authorized reinstatement of employees, this court has recognized that requires a higher showing, saying there has been a historic denial of reinstatement, right? In courts of equity. Equity means you can kind of correct the wrongs where you can balance the sides, essentially, right? Think of it like a scale. And so, well, no, they fired you, so we're shoving you back in, versus you might otherwise file a claim for back pay, right? Would be you're getting monetary damages versus an equitable remedy, which is shoving you back into the position. So the district court didn't care, plowed through those principles here, awarded reinstatement versus back pay because, FOIA delays and bathroom services and more. It was a sweeping order. It was badly out of step with the illegality that they asserted. And so they said OPM didn't have power to do this, and OPM didn't do it. So the issues raised here warrant your review, Supreme Court. We need you. The district court's order directs agencies to reinstate more than 16,000 fired employees across 6 agencies. Now, what is more, it also requires that employees be reinstated to active duty status and be provided with assignments, give them work, apparently such that the services respondent, they seek to benefit however they want. They can do whatever they want. This court has repeatedly intervened in cases where they have tried to interfere with the executive branch and the functioning of the president. This case involves intrusions on an even far greater scale. And so therefore, we need you to step in, Judge. There is irreparable harm here, Supreme Court. Judge Alsup's order causes extraordinary and irreparable harm to the executive branch. 16,000 employees have been ordered to come back. The court has recognized in another Supreme Court case that the government has traditionally been granted the widest latitude in the dispatch of its own affairs, but the court has expressed concern this court about the intrusion of a court order directing the reinstatement of a single person. An order directing the reinstatement of thousands is intolerable. Supreme Court, come on. The injunction from Alsup, the judge in California, appears to prevent the agencies from even terminating employees based on their independent judgment. Okay, that dude who was doing lines of coke in the bathroom, got to keep him, can't fire him, would even seem to prevent the employee's termination based on new grounds of like poor performance or misconduct. You at least have to go and talk to the judge because the judge is in charge of everything now. So this is ridiculous. Magnifying the harm, the district court has made clear that employees whom the branch has chosen to fire specifically must be returned to full duty status and given their jobs back. Now, the practical burdens of implementing this are enormous on us, the government, and the American people. It's us. In response to the injunction, agencies have contacted thousands of fired employees, offered them reinstatement, which has been a ridiculous burden. Those efforts are ongoing. And the agencies continue to work on onboarding employees who accept this reinstatement. That onboarding process is an extensive one. That includes assigning workspace. Oh yeah, this is going to be the bureaucratic compliance strategy. This is the your check is in the mail strategy, right? And then they get, you forgot to sign the check. I forgot to sign the check. Or even back that up. Where's the checkbook? Do you know where? Oh, God, I don't have the checkbook with me. My partner took it. Oh, it's gone. It's over here. You know, you can't. Very slow. And you can see there's going to be a lot to hire these, these thousands of people back for all these various agencies. Look at all this work. Yeah. Workspace, got to get them new desks, new credentials. You know how long it takes to get those key cards made up. Benefits programs, a lot of work there. Completing the required training before you can give them assignments. I don't know. Probably be like, what, 90 days? The reinstatements have logistical burdens, requiring substantial resources, effectuating reinstatement across multiple systems, and they were fired, and some of them have pleaded guilty to crimes. Wow, like they want us to reinstate a terminated probationary employee who had pleaded guilty to a crime to covering up a murder. And another who was found to be a foreign national from a country of particular concern. Wow. So the judge wants us to bring back criminals. Thanks, Judge. So in addition, the obligation to pay terminated employees is a massive financial cost that cannot be recouped. And so those burdens are staggering. Every single day, the judge allows this to happen, Supreme Court. And the injunction also requires employees that the agencies had terminated to be given the same work assignments. Regardless of other changes, maybe we're not even working on that project anymore. We're like, okay, well, you're in charge. Adding to the chaos, agencies have to make assignment decisions in the shadow of the serious uncertainty about the legality of that order, saying that they're going to be fired anyways. Now, making matters worse, the district court apparently intends to superintend all of this. Each day the injunction remains in effect, they are micromanaging the judiciary, the executive, saying he wants updates. So the balance of the equity, Supreme Court, strongly weigh in favor of the government and Trump. They have asserted possible disruptions to their bathroom use and more. But even if those injuries suffice for purposes of standing, they cannot outweigh the government's own authority to manage its own affairs. That is particularly so because a reinstatement of these 16,000 people already is going to be incredibly burdensome. Restoration of these services relies on the independent judgment of employees, not judges. As Judge Bade observed in the dissenting opinion from the lower level court, they offer no reason to believe that immediate reinstatement of the reinstatement or offers of reinstatement would even cure the defects. Would this fix all the problems or not? So no, you can't make that causal connection, so it's not valid. So they wrap up saying, the acting solicitor general respectfully requests that this court grant a stay while this works its way up. That would leave matters as they currently lie, with the probationary employees in district court required to be reinstated, remaining reinstated, at least in paid administrative leave status. But it would relieve agencies of the obligation of continuing to onboard them back to full duty. Can we just put them in hold till we work this out? Each day, that the superintendents of personnel matters is intolerable, Supreme Court, and warrants immediate relief while the court considers the government's broader request. So they ask this court, the Supreme Court of the United States of America, to issue a stay from Judge Alsup from San Francisco of his order requiring the rehiring, re-onboarding, new key cards, and all the things of thousands of government employees, some of whom I'm sure have moved on, but many of whom will love to get back in there and insurrect from inside the government. So that's what happened with Judge Alsup today. Now, what really is happening in a broader picture is that the government is not going to be the main employer and provider of services to everybody in the country, because the government is terrible at that. And we want these people who were let go to go get good new jobs in the private sector. And since they were, I'm sure, amazing people who are ultra skilled and making tremendous sacrifices for all of us, don't you feel loved? That they're going to just land in amazing jobs in the private sector, not worried about it at all. So here is Trump and Scott Bessent explaining what the big vision is, what we're doing here in America.
We are under your direction. We're reprivatizing the economy. We're bringing down government spending. We're bringing down excess employment in the government sector. On the other side, we're going to re-leverage the banking system. We're going to have all the new manufacturing jobs, so everyone who's laid off from the government will have an opportunity to go into the private sector, and that is going to lead to disinflation. Inflation is under control. We're going to get the affordability crisis fixed. So lower energy, deregulation, more private sector jobs that will naturally get interest rates down. Interest rates down. Mortgage rates are down almost every week since January 20th. The energy costs are down about 15%. Crude oil is down about 15%. And as we keep that going, interest rates are going to keep declining. It'll be good for mortgages. It'll be good for credit card debt. It'll be great for auto loans.
All right. Secretary Treasury, drop in numbers, and they all sound like they are trending in the right direction. Now, we also had Pam Bondi, who was out there. Of course, a lot of what we're doing in the federal government is cleaning out the fraud, waste, and abuse, and the hiring of many employees by the prior administration to just fill the government up with a bunch of blue individuals to support the giant bureaucratic state. Don't need them. The administration is letting them go and looking around for what else needs to be cut. And when that is found, when those devious criminals are discovered who were siphoning off of the government teat, they will be prosecuted, says Pam Bondi.
Is doing such a fantastic job. I thought maybe you could say a few words.
Thank you, President. As far as we are hearing a lot about fraud, waste, and abuse, a lot of waste and abuse, but there is a tremendous amount of fraud. And Elon, thank you for your partnership. Thank you for your team. You have uncovered so much fraud in our government, and we will prosecute you. We have an internal task force now working with every agency sitting here at this table. And if you've committed fraud, we're coming after you. Thank you, Elon, for that. On the violent crime level, thanks to President Trump's directive, we are seeking the death penalty again. So all of these horrible, violent criminals that you're hearing about around the country, they will face the death penalty federally within our country. And the drug dealers need to get out of here because we are coming after you. We're going to have 94 great U.S. attorneys around this country, and everyone will be prosecuted to the fullest extent of the law.
Thank you.
Thank you, President. It's at your directive.
All right, so that's Pam Bondi. We're looking forward to those indictments coming soon. Looking forward to them. I'm sure they're going to be here soon. So we're going to keep our eye on this case. Of course, the Supreme Court will let us know if they're accepting this or not, with usually just a little bit of a blurb saying you are ordered to respond by this date. So we'll keep our eye on this. Thank you for subscribing and joining as we do. Now, we've got another big update on the day. You can see we're jumping over to the District of Columbia, but let's start over here with this scene, because we're back in Washington, DC. Trump is in the U.S. Court of Appeals. We're fighting over the deportations that took place. Remember, Judge Boseberg was the judge who said, turn those planes around or else. And he issued a new order that came out from his courtroom in DC. We're going to read through this and see what his opinion is, but this is also being appealed. And so we're going to do a little bit of backstory with the memo and hit the highlights of it, but then turn our attention to the actual oral arguments that took place today in Washington, D.C., the Circuit Court of Appeals there. And we've got some judges there that we are familiar with. We've already heard from this judge. Judge Karen LaCroft was there today, who is a Reagan appointee, I do believe. We also heard from Justin Walker, and then there was another judge. Justin Walker was appointed by Donald Trump, and then there was another judge who was also there who we'll come back to. But we want to hear what they heard and said today, because they were calling Trump's deportation of these Tren de Aragua Venezuelan alleged gang members, represented by the ACLU and many others, saying that they were treated worse than Nazis. And of course, that is what you'd expect from the District of Columbia, but we'll come back to that. Here's where it starts. A memo issued in the deportation case coming out of the District of Columbia by Judge Boseberg. We spent a lot of time talking about this guy, and he's very mad about President Trump's use of the Alien Enemies Act to deport Tren de Aragua folks out of the country, back down to El Salvador, and afuera out of America. But here is what he has drafted for us. Coming out of the District of Columbia, Judge Boseberg writes, in the pre-dawn hours of Saturday, March 15th, 5 Venezuelan non-citizens being held by Texas DHS sought emergency relief in this court. What's so curious about this, too, is that it's Texas DHS that had them, and they sued in D.C. Why didn't they sue in Texas? We all know why. They justifiably feared that in matter of hours, they might be removed from the countries pursuant to not the INA, the Immigration and Nationality Act, but instead the Alien Enemies Act, a law last invoked in the wake of Pearl Harbor, right? So this is an old law. Why are we listening to old laws? You're like, well, the Constitution is pretty dang old. They're like, well, we hate that too. That act authorizes the president to summarily remove natives, citizens, denizens, and subjects of a hostile nation or government when there is a declared war. Now, the president, right, these non-citizens, these Venezuelans, they say that he had signed secretly a proclamation invoking the act, and that as soon as it was published, they were going to get deported. So as expected, later that day, Trump published the proclamation. He said, Tren de Aragua, violent national trans organization and criminal organization that has committed a predatory incursion into the United States, and we're deporting all of them afuera. But they said, no, the government was mistaken. Each vehemently denies being a member of Tren de Aragua. No, it's not us. No, we're just innocent. Several, in fact, claim that they fled to Venezuela to escape the predations of the group, and they fear grave consequences if they're deported solely because of the government's labeling. They then sought a TRO, preventing the government from deporting them or other non-citizens under the proclamation without a hearing, right? Now, this is going to be the big subject of this entire, of this entire case, really, is due process. And do you have a right to a hearing, a trial? How much due process should we afford to you if you are a non-citizen? They say to preserve the status quo, the judge, until their claims could be adjudicated, this Judge Boseberg issued 2 TROs that stopped the government from relying on the proclamation to remove people. Now, neither order required the government to release a single person. And this judge is now coping now. He's like, oh, what? You didn't want us to deport them? He's like, no, I wanted you to hold them. Neither order prevented the government from apprehending anyone, and neither order prevented the government from deporting anyone through authorities other than the proclamation. And that's what Trump says. Trump says, we did. We had plenty of other power and justifications to use these people. Tom Homan says the same. Indeed, as the president last month designated Tren de Aragua as a foreign terrorist organization, members of the gang are already inadmissible and thus deportable from the United States under the INA, right? And That's what Trump was saying. Anyways, the government now moves to, the judge writes, now moves to vacate the TROs, primarily on the grounds there's not a sufficient likelihood they're going to win, saying the president's unprecedented use of the act outside of the typical wartime context. We've been invaded by foreign countries for decades now. Finally, somebody is calling it what it is, an invasion, an incursion. The plaintiffs' various challenges, they say, well, just go file a habeas claim. If you're unhappy, just go sue in Texas under habeas. We can't do that. Implicates, the judge says, it's going to be too complicated from them, including sensitive questions about judicial matters. And now the court doesn't need to resolve any of this. That's because they are likely to succeed on another fundamental theory. The judge says, before they may be deported, ridiculous, they are entitled to individualized hearings, writes this judge, to determine whether the act applies to them at all. And here's my question. Did they get individualized hearings when they were invading our country? As the government itself concedes, the awesome power granted by the act may be brought to bear only in those who are, in fact, alien enemies. And the Supreme Court and the circuit have long maintained that federal courts are equipped to adjudicate that question. So it needs to be a hearing in front of a judge? Did these people come in? Did they get hearings in front of judges before they invaded our country? So how about we show them the same level of due process that they showed us, and or even if they came in legally, that the Biden administration showed them. I don't even care if they came in and it was a bunch of paperwork. Okay, who are you? Where are you coming from? Oh, asylum. Okay, you're here an asylee, immigration. Oh, you're fearful for your life? You are? Great. Okay, perfect. And where do you need to go? Are you going to be a drain on America? You're not going to be a drain on America, are you? No? Okay, perfect. Okay, perfect. Okay, where do you want to go? New York, right? Great. Okay, New York. Perfect. Okay, great. And all the other questions, no diseases or anything. Okay, great. Come on in. That was the due process to invite them into the country, so-called invite. So that's about as much process. They're not citizens. They haven't sworn an oath to this country. So whatever that status is, okay, whatever process that was, we can afford them that exact same process. I'm totally fine with that. Just same thing. Oh, looks like you might be Tren de Aragua. Anything to say about it? Okay, forms here, tattoos or whatever, okay. Verdict is afuera, right? That's due process because that's what we got from the prior administration. They set the standard. We're following their same standard. They had a freaking app that they were inviting people on. They were door dashing people into the country on apps. So we can just door dash them right out of here. We can give them as much process on an app. Here, just fill out this app. Red. All right. Oh. That's due process because they used an app to get them in. So we can use an app to get them out. That's as much process as I think they're afforded. Because the named plaintiffs dispute that they are members of Tren de Aragua. No kidding. They say they're not members of the gang. I'm shocked. They may not be deported until a court has been able to decide the merits of their challenge. How many courts adjudicated the merits of their asylee claims in a court of law by a judge? Well, you're right. You are an asylee. And that the government and both sides were represented. Okay. In other words, the alien was there and the government was there to say they're not here on asylees. Answer, none of them. In front of a judge and all that? No, Biden was handing them in, bringing them in hand over fist. That you went to a judge when you tried to deport them, when you tried to kick them out, but they were brought in by the boatload. So give me a break. They can have as much process. We can door dash them right out of the country. Stop crying about it, right? And if they want to come back into the country according to the legal process and become citizens, once you become a citizen, that's a whole different ballgame, right? That's a whole different standard. You've now sworn an oath, and it's a long time, and it's much harder to funnel people through, even though Joe Biden tried to do that. But okay, we continue. Nor may any members of the provisionally certified class be removed until they have been given the opportunity to challenge their designations as well. The motion to vacate will thus be denied. All right, so that injunction stays in place. Trump cannot deport terrorists. They're entitled to a judicial hearing. Okay, Tren de Aragua are entitled to a judicial hearing because a corrupt hack judge called Boseberg decided to usurp the presidency. Now, this case has gone up on appeal. It's at the United States Court of Appeals for the DC Circuit. And here is a little bit of what happened today, queued up to the juicy bits The person you're going to hear from are the Court of Appeals judges, along with the Trump DOJ, who is presenting their argument.
Let alone an opportunity to file suit. And so were those removals? I think there was one airplane that you said that was people were removed on other grounds. But there were two where the government hasn't argued that. Am I recalling the record correctly?
Your Honor, I believe so. I mean,
Two planes worth of people removed under the AEA, not under withholding of removal process, or removal of the ordinary INA removal.
the Title VIII process. Yes, Your Honor. But I think the fact is that 5 individual plaintiffs were able to march into court, file habeas, actually get relief, admittedly on non-habeas grounds.
They did.
And the fact that opportunity.
Without the government, I mean, that was a super fast order that was done, as you know. I mean, the government was called and notified, and then a hearing that afternoon. But that's one of the reasons there's all these separate disputes in district court about compliance, because planes were already loaded and taken off. And those folks did not have notice or an opportunity to challenge their status at all. And that's why there's had to be a class certification to slow things down.
Certified Tren de Aragua as a class of people. So a judge, and this judge in the Court of Appeals is saying, we had to certify them as a class because they couldn't call their lawyers fast enough to get somebody to file a claim to stop them from being deported. Wild times.
Till we have an opportunity for due process.
Your Honor, I think this court's decision in IM versus CBP is instructive on this.
Am I wrong about anything I just said factually?
Your Honor, I think it's incorrect that they couldn't have gone into court as the 5 individual plaintiffs.
No, but
also
the point here was that there were plane loads of people. I mean, it's a class action. There were plane loads of people. There were no procedures in place to notify people. Nazis got better treatment under the Alien Enemy Act than has happened here, where the proclamation required the promulgation of regulations, and they had hearing boards before people were removed.
Trump is treating innocent Venezuelan migrants worse than the Nazis, is what we just heard out of a Court of Appeals judge's mouth.
And yet here there's nothing in there about hearing boards. There's no regulations, and nothing was adopted by the agency officials that were administering this. People weren't given notice. They weren't told where they were going. And they were given, those people on those planes on that Saturday had no opportunity to file habeas or any type of action to challenge the removal under the AEA. And like you've agreed that 2 of those airplanes.
Everybody else got to file. Those 5 other dudes or ladies did. They filed. Why couldn't those other people file?
People were removed under the AEA. What's factually wrong about what I said?
Well, Your Honor, we certainly dispute the Nazi analogy, but more importantly, the fact is that individual plaintiffs were able to file habeas in time in order to secure relief.
Yes,
Wait,
Judge.
what
this court-
individual plaintiffs were?
The 5 individual plaintiffs that
That's not my question. My question is there were a lot more people. They wanted to bring a class action. They had to have some named plaintiffs. So 5 people filing habeas doesn't help everybody else on 2 airplane loads.
They are their own people. They can go hire their own attorneys and represent themselves.
Correct? And my question to you is, and you said those 5 didn't get put on the airplanes. So as to the 2 airplanes that I think you just agreed involved removals solely on AEA grounds, on Saturday, the very short time of the proclamation's publication, had no opportunity to file for habeas or even notice as to the grounds on which they were being removed. Am I wrong about that?
It just went too fast is what she's saying, okay? Issued the proclamation, you rounded everybody up. They couldn't even call their lawyers. Nobody could file habeas, and they were on an airplane and gone too quickly. So she just, same thing. She said it about 5 times now.
I think so, Your Honor. The fact that 5 individual plaintiffs did file habeas
Yes,
and did get relief indicates that they could.
I don't think you're answering my question.
Yes, he is.
My question is not as to the 5 plaintiffs.
How did they get into court? They must have called a lawyer or done something. So the other people on all of the other airplanes could have done exactly what they did.
How much time I want you to think of 5 other people on the first airplane. How much time when were they given notice that they were being removed under the AEA on the
Wild.
grounds that they were members of Tren de Aragua?
She's gonna
And
go
how much
hour
time
and
were they
hour,
given
minute by
between that
minute.
notice and being put on the airplane that Saturday, right after the proclamation was signed, to file a suit?
Your Honor, those facts are not in the record, and I don't know all of them offhand, but I think.
Okay, so
It's a-
go ahead, you think?
But I think the fact that 5 individuals were able to do so
No, they
indicates
got-
that
they got
others
lucky.
could have. Well,
They didn't, they filed suit before the proclamation was even published. I've asked you after the proclamation was published. And I assume these habeas actions that you're talking about, and correct me if I'm wrong, that are now being filed in Texas, have been filed since there's been a stay.
well, Your Honor, I'm talking about
that right?
the 5 individual plaintiffs in this case.
That's not my question.
I
The
understand.
question here is, if someone thinks there was a meaningful opportunity.
Ask them. How'd they do it? How did they get lawyers involved in their case to stop their deportations? Judge, ask them. I don't know. We don't represent them. Ask how they did it so quickly. So you can see, very painful hearing to listen to today. But the way that this broke down is we had some very astute legal observers out there, including Roger Parloff, not a fan of Trump at all, says hearing in the Alien Enemies Act just ended. We had 3 judges there: Judge Millett, Judge Walker, Judge Henderson. Here's how they break down the 3. Says Judge Millett strongly trending toward keeping the TRO in effect. So the deportations cannot continue to happen until they've got individualized hearings. All of these are just speed bumps in the road to try to slow Trump down. Judge Walker trending against, and Judge Henderson asked no questions. So to be clear, Walker seems to think the case should have been filed in the district court in Texas. And of course, that would make it much more difficult for them, which is why they didn't sue in Texas. They sued in DC because they knew they'd get some favorable rulings there. Margot Cleveland, amazing reporting. Please follow her. Professor MJ Cleveland on X says, so I finished listening to the entire hearing. My initial gut remains. Walker is 100% no jurisdiction because this must be brought in habeas in Texas. Judge Millett is 100% jurisdiction, upholding the TRO, and Henderson's going to be the swing vote. Says, my gut, Henderson, going to find with Walker more convincing, saying Walker can overcome her worst case concerns by saying it will enter the administrative stay for 5 days to allow for appeal, and habeas can be filed in Texas. This will not end contempt issue. You still have a contempt. So the judge is also trying to get Trump held in contempt. And she says, don't think that Trump, that will happen with the judge. But good stuff. Okay, so Margot Cleveland also reporting on that. Now, more can be done here. Jim Jordan just came out, made the announcement that they are going to be holding hearings for these corrupt judges. One person who's on the list is Judge Boseberg, who should be hauled in front of Congress to answer questions about what he is doing. Here's what Jim Jordan is planning.
Frankly, there's the broader issue of all these judges' injunctions and then decisions like Judge Boseberg, what he's trying to do and how that case is working. We're going to have hearings on all of that because particularly when you look at Judge Boseberg, it starts to look like this is getting totally political from this guy.
Yeah.
Particularly when you remember he's also the judge who was part of the whole Trump-Russia FISA court granting those warrants that allowed the Comey FBI to spy on President Trump's campaign. So we're going to look at that issue as well. But hopefully we can get that bill passed next week on the House floor, move it to the Senate, hopefully get it to the president's desk.
What do you think you're going to find here? It seems to me like it's pretty black and white. You know, you go, you find the judge that's going to rule in your favor, and it's been going on for 20 plus years.
Yeah, that's why we want to limit it to just that jurisdiction, just the parties of the case, so it doesn't have nationwide implications. But yeah, there's the way the left operates. They go to these judges and they go after President Trump, as the speaker indicated, disproportionately more there than elsewhere. But with Judge Boseberg, think about this. I mean, I think the president, with his order on these gang members sending him back, or sending him to El Salvador, I think constitutionally he's on solid ground. Article 2, Section 1, first sentence, executive power shall be vested in a president of the United States. Statutorily, the Alien Enemies Act, predatory incursion, that's certainly what this was.
Heck yeah.
Gang members coming here illegally doing terrible things. And then finally you got this judge saying this crazy decision turn the plane around, bring the bad guys back to America. That makes no sense. So when you look at all that, coupled with this judge's history with the FISA court, with the sentence he gave to Kleinsmith, the lawyer, Kevin Kleinsmith, who altered the document in front of the FISA court, it really starts to look like Judge Boseberg is operating purely political against the president. And that's what we want to have hearings on, this broad issue and some of what Judge Boseberg is doing. And so we're going to start those next week, and we think Senator Grassley is going to do the same.
Wow. Okay. So don't know if that means they're going to haul him in front of the committee or not, or send him a letter requesting his presence, or if they will just bring in other experts, which is probably more likely. They'll just bring in, Jonathan Turley, who's a nice and intelligent and appreciated person, but he's not a person who can do anything to the judge other than comment on what this judge is doing. So we'll see what happens, but Jim Jordan will have some hearings. Got to have hearings before you can impeach him. So at least it's something. So they're back there doing that. We got Tom Homan, meanwhile, saying, we're going to continue to use our alternative sources of power. All right, we're going to find them and we're going to get rid of them. Here's Tom.
We're going to keep arresting TDA members. We're going to keep arresting MS-13 members. We're going to keep arresting public safety threats all this nation. Now, when it comes to Alien Enemies Act, if we're going to remove them through that act, we won't have to wait for litigation. We'll simply detain them. But we're going to take them off the streets. And anybody can remove through Title 8, we'll remove through Title 8, which is the order of an immigration judge. But we'll obey the court's order. But I think DOJ, I think eventually will win that order. Then we're going to keep doing what we're doing and taking these public safety threats, especially TDA and MS-13 members off the street across this country. It's a 24/7 operation, and we're going to continue to do that.
All right. So Tom Homan out there getting after it. And, of course, Pam Bondi was also out over the weekend hitting back on Boseberg, saying Americans are safer today, and we're not going to let up on these efforts. Here was Pam Bondi, Attorney General.
This is an out-of-control judge, a federal judge trying to control our entire foreign policy, and he cannot do it. He dragged us into court on a Saturday without any notice, and then he's continuing these hearings. He's trying to ask us about national security information, which he is absolutely not entitled to. We are appealing. We will be in court Monday. Again, we will win. We will prevail. There are 261 reasons why Americans are safer today, and that's because those people are now in an El Salvador prison. And we are going to follow the law, and we are going to protect Americans. There's a reason why Biden's approval rating was plummeting because of the border. There's a reason why the current Democrats' approval rating is at 29%. People want to be safe. This is President Trump's agenda to keep Americans safe, Maria. It's basic public safety. Get these people out of our country as fast as we can. They're not immigrants. They're illegal aliens who are committing the most violent crimes you can imagine on Americans. Murder, rapes. Ask the parents of all of these young women who have been violently strangled, raped, and murdered. And we are going to continue to make America safe again because that's President Trump's agenda. Yeah.
All right. So Pam Bondi is, I think, right that we do need to get a handle on the border and get people deported. These people were deported. They weren't charged, and so we're looking to see if charges do come at any point in time. But Pam Bondi is out there supporting the efforts and, of course, pushing back on Judge Boseberg, who deserves it massively. So we'll be here continuing to cover this. We know that the Court of Appeals will be taking some time to rule on this, and when the decision drops, we'll be here to cover it. Thank you for subscribing. Thanks for inviting a friend or family member to come over and join us when we go live. We'll be back here on the next one. But now, my friends, it's time to hear from you. Let's see what we got. A quick recap if you're just joining us. 2 segments today. The first one was a big one. The Supreme Court, of course, now getting a knock on the door from President Trump. And they submitted this. This is the case coming from California with the 16,000 fired probationary employees who all are suing to get their jobs back via the union. So that is what the Supreme Court has. We're going to wait to see what they do with that. We'll probably have some updates on that one this week. Then we talked about Judge Boseberg and the DC Circuit Court of Appeals because Boseberg issued a memo saying that Trump can't deport these people and basically set the new standard saying they all deserved individualized hearings and they're going to cry about due process. And my response to that is they can have the same amount of due process going out as they came coming in. The DoorDash, CBP app, Uber delivery app is good enough for me. So we covered that. We heard from the DC Circuit Court of Appeals, heard a little bit of her calling Trump Nazis, and then got reaction from some legal eagles and from Jim Jordan and more. But now, my friends, it is time to hear from you. And I'm really glad that you're here and with us. Thanks again for being here. Thank you to those of you who brought in some new membos for us. And welcome aboard, new membo friends. We had a great members only stream this morning. So if you're looking for some additional content this morning, we talked about, what did we talk about this morning? So many fun things. I can't even remember, but they're always fun streams. Great stuff. So check those out. And we'll see you tomorrow on the members only stream, whether you join on locals or join on YouTube. We'll be back here tomorrow in the morning, 12 noon Eastern for the member stream. And we'll see you there. Now, let's see who's here today, my friends. And thank you for your support. Thanks for sending in these super chats and being so amazing. Let's see who's here today. We got some new membos. What's up, Tony? Hey, I see you were here. What's going on? Hey, we got a Star Wars meme. It's R2-D2. Yeah, Monday mood. Plopping down. Good to see you. That's Donut clipping for us. Says, hey, wasn't Trayvon Martin using lean? Trayvon Martin. Wasn't that Obama's son? I don't know. Was he using lean? I don't know. We have to ask Obama since it was his son, I think. Thank you for that, Steel Manning. Hey, Rick Bing is here. What's up, Rick Bing? That guy. Rick Bing, thank you for bringing in 5 membos, Rick, for being a membo yourself, bringing in 5 more. We got Hyphen Snyders in here. We got Amiana List. We got Charles Guptill, Blue Star, and Anthony. Gifted membos, courtesy of Rick Bing in the house. What's going on? Rob MAGA Patriot in the house. Says, hey, imagine how many special elections there's going to be once arrests are made for insider trading and Diddy and Epstein involvement. Yeah, that'll be interesting, right? You see a bunch of Congress people and senators all resign. All of a sudden, I'd like to spend more time with my family. You know what? Dan Goldman, all of a sudden, I want to spend more time with my family. Like, what's going on, Dan? Where were you? I know he's pretty new to the game. I don't know if he was around. He was a prosecutor probably during Epstein's time. What's up, Sportfish? Says, Rob, do U.S. judges really have jurisdiction of military personnel since they have their own uniform code of military justice? Well, I would say that they're parallel systems. So, like if you're in the military, but you get a DUI, driving around on civilian streets, like the civilian police are going to arrest you. I mean, in other words, the non-military police will arrest you and prosecute you there. So like they will also have jurisdiction over you, and the military will also do something about that for you as well, right? So they have jurisdiction over you, but just because you join the military doesn't mean that the rest of society loses jurisdiction over you. You just kind of add in a new layer of authority over you, which would be the military. Good to see you, Sportfish. What's up, Kathy Morris? Thank you, Kathy, for becoming a membo. We'll see you tomorrow as well. Grab this morning stream. It was fun. Rob MAGA Patriot says, immediate ban on forum shopping. I know. It's like all these people are sitting in Texas. You could file a habeas claim in Texas, but instead you sue to get Boseberg to certify it as a class so that then all of them now get hearings because you guys love terrorists and your gangbang lawyers. I mean, gangbanger ACLU lawyers all love them. What's up? Thank you for that. Golden Gaming says, Justice Roberts allegedly takes bribes via his wife. Oh, that's not good. Well, I'd like to see some more evidence on that. If you got it, Golden Gaming. Thanks for being here for 22 months. What's going on? Michael McKenna says, anyone else see Roberts is in legal progressive American Inns of Court? Yeah, I saw that. I think Pepe's grandma had a good post about that. Says also a member's SC Jackson in Boseberg, condemning Trump, showing he's taking up for his own, calling them DC weasels, from Michael McKenna. Yeah, I saw a post about that. I think it was from Pepe's grandma. So thank you for that, Michael McKenna. Interesting stuff. Would like to see some more details on that, a deeper investigation. Art Pollard, how to send Robert good chocolate. Oh, well, I got a new address. So I'm up in Prescott now. I've got a new address. I'll have to get that on the website. Art, I don't think it's on the website yet. I don't think so. So I'll have to get that up there. But good chocolate. Man, that sounds good. I like good chocolate, not bad chocolate. Thank you, Art. Hey, Bonnie says, our son got to keep his probationary employee under the USDA, but it wasn't a one-size-fits-all. But he did lose 50% of his staff due to the fork in the road and early retirement offers made. 6% of new jobs created under Biden was federal government employees. Yeah, it made the numbers look good. Yeah, 40 to 50% of all new jobs went to non-citizens. Yeah, it was just fake numbers. And government spending goes back into GDP, and then the government spending hires some people, so they come out, we're hiring people, and the government's growing, the economy's growing. No, you just printed fake money. You're just goosing up the numbers. So we don't want to do that anymore. Hey, Quadcam says, I've been doing some similarities lately, digging on similarities between the 1800 election and the 2024 election. They are surprising. I've been working on a draft article summarizing it that I'll post to your locals later this week if you're interested. Yeah, that'd be awesome, Quadcam. What I would suggest, if you're into writing articles and stuff like that, I think maybe you would start a Substack if you don't already have one. But in other words, rather than posting just the text, post a link to your Substack or your blog or whatever you're working on. That way we can send some love your way. So that sounds very interesting. 1800 and 2024. Yeah. And I love articles about cycles and stuff like that, because I think there's some interesting patterns that emerge. Gail Gafford, happy anniversary, Gail. 1 year anniversary. Says this was all planned before Trump even took office. No doubt. Yeah, they've been wargaming this for a while, just like they did in 2020. This was their backup plan B. Man, I think that it caught them by surprise a bit, but they're now arming up, and they've got a little system and a pattern underway. Rogue, what's up? Thanks for the dono. Very nice of you to send that in. We appreciate you. Hey, what's up? Sketch Therapy. We got a new baby. We got Sketch Therapy, 9 months as a member. Thank you, Sketch. That's long time here. Says the hiking judge needs a colostomy bag, travel bag. Yeah, it's like, just dig a hole, bring some biodegradable toilet paper, just let her rip out there. It's all good. You can be one with nature, Judge. Touch some grass. It's good for you. Rogue says, Trump's the only guy many of us take seriously because he does things. He actually does things. And that's why we like him. All these other people just talk and send letters. We're going to hold a hearing on this. You're going to hold a hearing? Okay, I guess I'll be excited because that's better than, not holding a hearing. But all right. What's up, Rogue? Thanks for that. Hey, it's the Munkets. Tony, hey, Munkets. What's up, Tony? Hey, thank you for bringing in 10 new friends for us. We got this one. Aubin Ann coming in. Cornelius Buttknuckle. Oh, is our new member. Can't wait to meet you, Cornelius. We got West WV Sniper. Sean Simmers. Lady R. We got Kelly Salnow. T. Shuret. Jake is here. Swede 4 DJT. What's up? And Bill Carson. Gifted membos courtesy of Tony Hay Munkets in the house. Thank you, Tony Hay, for bringing in 10 new friends. Hey, Sharpening Man in Texas says, is there any end in sight, brother? What do we do now? Yeah. Well, first of all, Sharpening Man in Texas, we're winning. All right. It may not feel like that sometimes because a lot of this can be kind of doomy and gloomy. Like one judge just did this. Like, I know it's ridiculous, but we're still early in the game. All right. So by day, we're in month 2, basically. Yeah. So another 30 days from now, I think a lot of this stuff will be well past the TRO phase. Like the big stuff will be past the TRO phase, well into the preliminary injunction phase. Once we hit preliminary injunction phase, then we start to get to appealable stuff, right? So now we're going to be moving on into the Court of Appeals. We spent the last 60 days here doing this TRO stuff. Don't get me wrong. There'll still be TROs, that will reset the clock. But by about 90 days, then we'll get up into the appellate courts. Then maybe another 90 days from there, the Supreme Court will start to solve. It may not take that long, but by 6 months, I think a lot of this stuff is going to be sorted out from this TRO preliminary injunction stuff. Like, we're not going to be dealing with this the entire administration. Okay. Like, we're just not. 6 months from now, because you have to consider a lot of these TROs are coming out now. Like, they're just like day zero is like now. So yeah, I would say give us about 6 months. We're going to start to see some of this get settled out. Now, it's still frustrating and annoying because that's 6 months of time that we're not getting, and they can cause a lot of damage during that time. But the Supreme Court, that's what they're doing. They're going to make us go up through the Court of Appeals. The Court of Appeals will delay. Some will move fast. Some will move slow. But they're going to let it work its way out. And then 6 months from now, we'll see. Hey, what's up, this old guy? Oh, this one, rub some dirt on it. So don't get deflated, my friends. Like, these people are showing us who they are, by the way. Like, they're terrorist-loving ACLU gangbanger lawyers and terrorist-loving judges who are like, they need hearings. Don't deport them. Like, oh my gosh. All right, thanks for showing us who you are, okay? So the silver lining is that. And there's not much they can do. Trump and the administration will be engaging in bureaucratic compliance. It takes forever to get stuff done. It takes forever. Lost the checkbook. Forgot where the pen is. Can't forget the pen. We're out of ink again all of a sudden. The toner. Yeah, I tried to shake it. The toner's out, though. We can't print anything, so we're not going to be able to get that printed for you. So anyways, rub some dirt on it. It says Rob has a new member for his disc club. Scott Bissent. Disinflationary. Rob says disambiguate. Did he say disinflationary? What's a good word? Disinflationary. And disambiguate is a great word too. I don't know if it's a real word or not, but it should be. This old guy says, last question on the Biden immigration questionnaire. Do you prefer aisle or window seating? Yeah, it's like two questions. Yeah, it's like, are you alive? And do you prefer aisle or window seating? Like, yes, I'm alive. I don't know. Leg room, aisle. Congratulations, you're going home. Thank you for that. Yeah, look, I am a humanitarian here, all right? I want them provided the same due process that they got coming in because I care about them, just like Joe Biden did. So all of those people who just ordered Uber service into America, Uber right out. Bye. John McGarvey sending in for the tip jar, saying this one's for my language. So I don't know what you said, John, but he must have been unloading in the chat because John doesn't do that much. So probably vulgar. Very vulgar. We'll have to look it up. Hey, Deplorable Cleric says, how do I dub up this stream? All jokes aside, love what you do, from the Deplorable Chick. How do I dub this stream? I don't even know what that is. So you're asking the wrong guy. I don't even know what that is. So you're going to have to ask a dub up expert, and then they'll be able to guide you through the next steps. But thank you, Deplorable Chick. Thanks for watching over on Rumble, and thanks for being a membo over there. We appreciate you, and thanks for joining us today. Darkborn, what's up, Darkborn? Says, my question is, how do illegal aliens have due process on removal for breaking the law by entering illegally and other laws and being members of a gang that's been determined to be a terrorist organization? Make it make sense. Yeah, you can't, says Barnes. Yeah, you can't do it. It's hard to do. It's wild. All of a sudden, all these people, like, they need due process. They need to have a trial. And listen, I'm for due process. I'm a criminal defense attorney. I love due process. That's what we fight over, like, all the time, basically only about due process most of the time, is fighting about it. Big fan of it. But our country has also been invaded deliberately by our own caretakers, by our own supposed elected officials who care about America. We don't have time for everybody to have hearings on all of this stuff. So it's a matter of national security. They're not citizens. We have plenty of leverage in the law. They get plenty of process. If the prior administration had granted due process or enforced due process at the border, they'd all be here legally with no problems. We'd have no issues, right? Oh, you got a visa here. Oh, great. Oh, you're not a gangbanger. Oh, okay, great. So they would be here. But we have to afford the same inbound systems as outbound systems. It's only fair. No one's above the law. Thank you, Darkborn, for that one. Yeah, it's strange to watch them suddenly pop up and be due process aficionados and connoisseurs when they were watching the FBI raid and ransack and create fake crimes for our U.S. citizens called the J6ers, right? So I don't have any sympathy for that. I care about our citizens, not about terrorists. They have an opposite effect. What's up? That's a shame. Well, we gave the Nazis new identities and cushy jobs. So yeah, I think that was called Operation Paperclip, right? Kind of flew them all over here and they're like, hey, you guys are pretty good scientists. What else can you build for us? Hey, what's up? Clark Blunt. Thanks for being a member. 2 months here. That's a shame. Clark Blount is here. If the courts and Congress won't stop the lawfare, I am going back so we can't vote our way out of this corruption. I am going back to we can't vote our way out of this corruption. I see what you're saying. Yeah. Well, don't give up yet. I think we're still in the early innings of the game, and we're winning. Like, by the way, okay, we're definitely winning. Trump is these people are on their heels. They are freaked out. They're suing. They have to go into their pockets, and just think about that, right? They all have to spend money and time. We have the federal government. It's like Goliath times 1 trillion. The federal government is basically undefeated. Okay, it wins every time. Trump controls the executive branch, so we're winning. Even if these judges are doing things, like the judge is not in control of the executive branch. There's only so much they can do. Rub some dirt on it. In other words, I'd much rather be in our position, much times 1,000,000, than on the other side with these hack judges. Hey, what's up? Rub some dirt on it. I think requiring a $2 tip for your word choice dealt with you disproportionately. Disproportionately. Tag there for us in a way that is either too large or too small in relation to something else. The question is, in what direction? Is it too minor? Like, is John dropping like, the C word or something? And he's like, oh, $2 will cover that when it won't. I don't know. Crystal Stouch. What's up, Crystal? 1 month as a membo. First month's the hardest. Gets easier from there. Thanks for being here, Crystal. Hey, Rob, big fan. Thank you, Crystal. Thank you for becoming a membo. Really appreciate it. We'll see you tomorrow on the Membos Only morning stream. It'll be fun. Nacho Mama, here for 7 months, getting closer to a baby, says getting closer, LOL. It's almost baby time, 2 months. We got full term. Imagine how much time that is. It's a lot. Thank you, Nacho Mama. We'll see you when the baby arrives as well. Michael Waller, thank you, Michael, for joining up as a membo. See you tomorrow. Grab the stream from this morning. Crystal, good to see you again. Crystal Stouch says the judge said the 5 filed before the proclamation. Yeah, and I think it was like simultaneous, and that we saw that in the filing. But their filing was that they think that they're going to, they phrased it, but it was like back to back. They filed the law. I don't know timing, how close it was, but they said, we're getting deported. Trump is going to issue a proclamation, and then he's going to deport a bunch of other people. So like they had, either way, I don't think it really matters before or after the proclamation. Either way, they had notice, and they got lawyers on the case. So the fact that they got it before the proclamation was issued shows how much due process and how much time they had. Now everyone else has a proclamation. Now they're on notice. So now they should be thinking about legal defense if they're going to be deported or not. So the fact they filed before the proclamation was even filed said, look, Trump gave them plenty of time. It wasn't even public, and they were suing, and they won. They didn't get deported. So who cares? Will, what's up, Will? Says Boseberg knows he does not have subject matter jurisdiction over nationals of national security. Congress should legislatively delete his court. Legislatively delete his court. Yeah, that's an action that a lot of people are talking about. Modifying the jurisdiction of the courts. Good stuff. Thank you, Will Crump. Hey, Rob, did you watch that video yet? No, I did not. Jay Water, Road Less Wolf. Thanks for being here for a full year. Was busy prepping for the show, my friend, but we'll add it to the list and we'll see if we can get to it. But thank you for sharing it with us. Golden Gaming says like and share with friends and family and get Rob out in the tubes. Get Rob out in the tubes. Thank you for that, Golden Gaming. We appreciate that. Thanks for inviting everyone you know. Force them to watch the show. Just say, listen, you're going to like this guy after like 2 weeks of this. So just sit here and just deal with it for 2 weeks. Okay. Then he'll grow on you. You'll understand what's happening. Maybe. And if not, that's just too damn bad. Just sit here and watch it. Rob, remember, I asked what was going to happen with the deal when Schumer swearing in judges at midnight. Now we know. Yeah, that was the old switcheroo where they had to deal with McConnell and Schumer, and then the Democrats backed out. They said that they would retire, and then they unretired after Trump won. And meanwhile, the Republicans gave everything away. Rob MAGA Patriot says, what if Trump enacted martial law? Can federal judge stop a president from enacting martial law? Can you give us some details on martial law? I'm opposed to it, are the details that I can give you. So yeah, I'm opposed to it. So it should not happen. Those are the details. Doanne, what's up? What do Boseberg's conflict of interest play in? When do they play in? Yeah, I mean, you would see something like that maybe in a motion to disqualify, like we read last week, a motion to disqualify Judge Beryl Howell. So in a situation like that, where she said certain things, you could see them pop back up. We got Tony Hay Munkett says, sometimes I have to check myself. It's only been a few months. That's right. Trump is kicking booty. After 4 years of Biden, I just want everything done now. Yeah, I know. The law is slow, right? The law is very slow in general. And so it's important to keep that in mind. I got to remind myself about that because I'm the same way. But even practicing, right? It's just, hey, it's slow. It's like takes time. People get arrested and a lot happens very quickly. And then the process takes forever. Where are my blood results? Don't have them. Why not? Well, I don't know. Ask the State Department. Or ask the state DPS, right? The Department of Public Safety about why they haven't processed it yet or whatever. So it's slow. I know it's frustrating, but this is just the court system. You'll hear many lawyers explain to their clients that their clients have the hardest job in the world. They have to wait. And maybe the second thing they'll say is, and you have to trust us, like we're looking out for you, which are hard things to do, man. If you're in a legal spot, it's very hard to trust somebody and to wait. It's like the hardest things in the world. So we're there. We're like America's client. We have to just sit and wait. Oh, I know. Gail Galford. What's up, Gail? Thank you, Gail, for sending this one in and for being a member. We appreciate you. We got Deplorable Chick says, double up dude. I still don't know what that is. Does anybody know what that is? A double up apostrophe dude? Double update, maybe? Or there's an apostrophe there, clearly. Double up dude. Deplorable Chick? I don't know. I think maybe I'm getting too old. Is that what these kids are saying these days? Double up dude? It must be update, right? It must be. Thank you for that, Deplorable Chick. We do 2 updates a day, baby. There's a lot to cover. We got a lot to say. Amazing. Dan, all of these illegals are to be housed in the judge's home. That story will change. Yeah, that would change real quickly. Just put him in his district and see how he likes it. We don't want anything bad to happen to anybody. Dan, thank you. This old guy says, hey, Rob, thanks for keeping me sane during all this district court foolishness. You too, this old guy. Thank you, my friend. We go through it together. Honestly, if I was just sitting here, reading it myself, and wanted to throw stuff out the window, but I still have that feeling, obviously, but we get to express it together and it's much more peaceful and enjoyable together. So thank you, this old guy. Thanks for the nice dono. Thanks for being an amazing membo on Locals. We appreciate you. Rob says, if the judge wants them back, we'll deliver them to his personal residence. Yeah. And then the DOJ can just sit around and not do anything about it because there's precedent for that. Thanks to Joe Biden. Deluxe Knight. What's up, Deluxe Knight? I agree. I want the same due process for the illegal invaders got on the way into our country. Absolutely none. Load them up on planes, evacuate them like Biden's failed Afghanistan retreat. Yeah. Except we'll actually put him inside the plane, which will be good because Joe Biden didn't do that. They put him in the wheel wells. That didn't really work out for him. So yeah, look, and I'm for, we don't want to make mistakes. We don't want to deport people who should not be deported. Like citizens should definitely not be deported without a hearing, stuff like that. But certainly this idea that they're entitled to massive due process and the protection of citizens after they've broken the law and done so with malintent to come in here and commit crimes and to invade the country and exploit the country for their own selfish and criminal ends doesn't mean we have to give them all of the same benefits and privileges of a citizen. And by the way, I'm not for violating the Constitution in regards to cruel and unusual punishment, for example, or if we charge them with a crime, right, you give them due process and the presumption of innocence, and they get a trial with the same standard beyond a reasonable doubt and all those things. For all of that, if you charge them and if you deport them, you give them a separate set of standards for the deportation component of this, and they're not citizens, so they're not entitled to all the benefits and privileges of a citizen. It's not that complicated, but they happen to love terrorists, apparently. And I love to be so reductionist on that one because it's just fun. Sheila the Pooh, what's up? 10 membos. Sheila. Thank you for sending that. What's up? 10 membos coming in. Blex is here. Gundam Axia. We got G-Men. We got Aaron. JJ. We got Jake. Go Ho Shane. What's up? Patricia. Victory. Rosie's here. You don't even own a suit. All coming in courtesy of Sheila Pooh. A million hugs to you. Thank you, Sheila, for bringing in new membos. Hey, Pinochet's helicopter tours, the most exciting helicopter tour you've ever been on, says, well, there were those SS at Dachau, something from Pinochet's helicopter tours. Thank you, Pinochet. Trying to get our stream thrown out of a helicopter. Deplorable Cleric, what's up? Says, forget the T. Forget the T. Double updo. Updo. So forget the T there. Double updo. Much clearer now. I don't know what you're talking about. And I'm trying. If something's wrong with my brain, I'm drooling all over myself like Joe Biden too. My brain's short-circuiting. Oh gosh, deplorable chick. Doanne says, when does Boseberg run for political office? Why? Why would he? Why would he ever leave? An updoot. Oh, an updoot is a thumbs up and a downdoot is a thumbs down. But she said there is no T, so delete the T, so it's an updo. I don't know what's going on. I'll take that, though. That sounds cool. Hey, what's up? Okay, Will Crump. Courts below SCOTUS creations of Congress. Congress can therefore get rid of problematic districts. I think Franklin did it in our founding era. I think it was Lincoln. I think Lincoln got rid of the District of Columbia. Is that right? Double check, fact check me on that one. But I think Lincoln did some major modifications with the court at the time. Yeah, he did, because the court was very southern in DC. It wasn't the Supreme Court, but the District of Columbia court was very southern. You know, the District of Columbia is like a new thing. It's not like a historic thing where they had a federal court system. It's like back in the 60s is when it came up as a federal, divergence. So we don't need it. Rob Maga Patriot, what's up? Says, why was there appeal? I'm not questioning jurisdiction on Article 2 powers. Well, there was an appeal. They are questioning Article 2 powers. They're saying the executive branch can do these things. The courts are saying they can't. So that's essentially why they appealed. Rub some dirt in it, on it, usually goes in it, but it's to help it coagulate. It's good for you. Thanks, Rob, for keeping us all from becoming disillusioned, disinterested, disenchanted, or disgusted, or even worse, disambiguated. You don't want to become disambiguated about politics here. Definitely not. So thank you, Rub some dirt on it for that. We definitely don't. We do not want to get disinterested or disgusted or disenchanted. And as much as the Supreme Court is not a political body, technically, it is very much. And so we keep the political pressure on, keep the outrage visible and evident. They see that, right? Because the court, a lot of their power stems from their legitimacy and their credibility. And when the populace is unhappy with them, things start to change. And that might be the reason why the FDR and the switch in time that saved the nine, FDR came in, wanted to pack the court, tried that. That was very unpopular. But the people were also, history says, unhappy that some of the court was being obstructionist to FDR's policies, right? So you could say like Trump is a reframe or a reincarnation, a mirror of FDR in a way. FDR built like history in reverse. FDR came in, created a massive, state, bureaucratic state. The court was obstructionist. The courts were obstructionist. he made a big play to pack the court. The court shifted thereafter. Historically, it's called the switch in time that saved 9. Started agreeing with the Commerce Clause legislation and all of this other stuff that expanded the federal government's power massively. And then he never packed the court. So Trump could be the inverse of that or the reverse of that, right? Trump comes in, makes all of these hard changes. The courts are obstructionist for a minute. Trump does something. Courts reverse. All this stuff gets done. The deep state gets eviscerated, you know? So it could be the reverse. History in reverse. Just mirror that. What's up? ELZ says anti-disestablishmentarianism is the word John McGarvey used. I suggested a $2 tip. Since I just used it, I need to pay up too. Well, that's like at least a $3 word, isn't it? Like, how many syllables are in there? A lot. What's up? Archlord says updoot is an upvote, so it's thy really support it. Well, that's the nicest thing ever. That's a Reddit phrase, isn't it? It's an updoot. Sounds a little too playful for me here. It's like I'm gonna give you an updoot. Like, I don't know if I want that, really. I mean, I understand. I appreciate the sentiment, you know, but it's a little too like, you know, kind of thing. Hey, G-Men shared that, which I don't know what that is. So thank you, G-Men, for sharing that. Rob is here, says it was cruel and unusual punishment, inviting them to come across the border against the law. Yeah, they did that basically. And made it, they facilitated it with apps and incentives, like go to New York and get a hotel. Will Crump says Lincoln did in fact dissolve the DC circuit. That's what we thought. Yeah, Lincoln wasn't playing around either. Corrupt DC courts. There's a lot of history there. And there's an interesting timeline. Actually, it's on the DC Circuit Court website. Very interesting timeline showing of how it was established and all the things. John McGarvey says, even Stephen. There you go. $3 word. Anti-disestablishment. Thank you, guys. I should have made it a lot more than that. You know, it's like a $50,000 word, John. Okay, not that much. You get the point. Thank you, John, for closing the gap. ELZ sent it in too. Okay, $3. There you go. Sent in. Close the gap. Close the deficit. Thank you, fellas. Doanne says most millennial conservatives in over 50 years, according to the polls, thanks for Trump, no disambiguity occurring here. Yeah, and the youth of America are also going to have to hit reality at some point, right? And so when they realize, like, oh yeah, Joe Biden, I think they may have realized, oh, after Joe Biden, they promised us all this equity and inclusivity and all this crap, but I can't buy a home. I can't save $1. Everything is expensive as hell. My education is ridiculous. Nothing is meaningful because everybody has fake degrees from everywhere. It's all just useless, made up stuff. And what am I supposed to do with my life? Culture's been rotted and evaporated. Can't even have an idea of what a man or a woman is anymore. No one's dating anymore because everybody's swiping each other and pornographied their brains out. So what are you supposed to do about it anymore, right? Everybody's waking up and saying, oh yeah, maybe there's a better way. Looking for answers, and we're glad they are. Thank you, Doanne, for that. ELZ, appreciate that. Economath, the conventional account of switch in time narrative has been disproven by historians. The switch happened before FDR announced 6 weeks court packing plan. Well, then I've heard that too, right? And I've heard that. I've heard that the judges were not persuaded, and it's actually kind of just one judge who started the trend and the switch. And if you look at the history, I think that the case law switch, it kind of, they just frame it a little bit differently. So I think that argument is fair, but it is also interesting that it happened basically simultaneous, right? And then after the announcement of the court packing plan, the whole series of Commerce Clause stuff, everything shifted pretty dramatically, right? The Commerce Clause got expanded massively and much more. So yeah, it is a historical note, right? If you look it up, you'll see a bunch of people talking right about it. The switch in time that saved 9. It's got even a nice little cadence to it, but there are historical questions about it. But I think that the pattern rhymes. It's kind of poetic in a way that Trump might be coming in and doing the opposite, right? History's like kind of like a spring, right? Like it goes out and then it comes back in. Goes out, or like a pendulum. We use that analogy a lot. as well. So it swings one way, goes the other way. And the court is usually, the law in general is usually kind of like the slowest thing to ultimately adjust and take some time, like it's the last part of the pendulum to swing back the other direction. Okay, we're going to say what's up to some friends on X real fast. Then we're going over to locals, to our Watching the Watchers members only after party. We had some great comments in here. What's up, Chris Sheehan? Our president is doing all he can to protect the Constitution. Great to see you, Adriana. Says amazing live. Thank you, Adriana. Very nice of you to say that. Furious judges. We the people are very happy with the deportation, says Abby. Jody says, Rob, how is it that public servants can have a union? Does that mean that we, the taxpayers, are in the unions also? Well, I mean, we're in America's union. They're in different unions that only care about themselves and literally sue America because they want their jobs back. Thank you for serving your country. Since we pay the salaries and union dues for the federal workers, hit the like button and God bless you all. Yeah, we are. We're basically in the Union of America. And we have a bunch of other sub-unions who think that they're better than us. Howdy, Rob, from Richard. What's up, Richard? Tatership, leaving X to join the family on YouTube. See you over on the tubes, Richard. L, thank you for the insight. What's up, L? Good to see you. Says thank you for the insight. Thank you, L, for joining us. And there is another L, not that L. We got two L's out there. We got L also on X. Many of you probably follow her as well. Good to see you, L. What's up? Okay, so my friends, thanks for following us out over there on X, and thank you for joining us on this Monday stream. I think it's going to be a jamming week. I can feel it in my bones. And so we want to thank our amazing mods and meme smiths who mod the fort down for us and keep things nice and beautiful and orderly around here. K-Bean, Donut, Mind Me, Carrie B, Playing Hooky, Dog Digger, and Janek in the house modding the fort down for us. Of course, we've got Geegum, our meme smith extraordinaire, Just Rhonda, our purveyor of fine emojis, and Elliot, our doc master, keeping things beautiful here. We're grateful for everybody who joins us and helps keep this place vibrant and full of love and fun. But my friends, we're going to leave it there on the night. Of course, it's Monday. We're going to have a jamming week ahead. We're going over to locals, watchingthewatchers.locals.com, members only after party. We're going to have a great time over there. Members, we're back tomorrow morning as well, 12 noon Eastern. We'll see you on YouTube and locals for the members only morning stream, noon on the East Coast, but you know what I mean. So we'll see you then, my friends, but we'll pause there for the evening. I want to thank you for being here. Tomorrow we're coming back to get into it again. In order to do that appropriately, we are going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.